G'day everyone and welcome to video 4.2.4 for the Legal Studies guy, where we're going to look at some factors affecting the ability of courts to make law. A quote for today from an unknown source: "The fridge is a clear example that what matters is on the inside." If I can turn that into maybe a deeper quote than what it is on the surface, go to its inside perhaps. Obviously, teenage years are pretty big time for things like body image and all that sort of stuff to become concerns in people's lives, and just a reminder to always be looking to what people have on the inside and what their values are and what they stand for, as opposed to just what people look like. So, as I said, today we are looking at factors that affect the ability of courts to make law, and this is one of those dot points that delightfully has 5 parts. So we know exactly what factors they need us to look at, but obviously that means there's a little bit of depth to them. So the 5 factors are precedent, judicial conservatism, judicial activism, which kind of work together, costs and time in bringing a case to court, and the requirement for standing. This is our key skill. Again, we went over this with dot point 4.2.1. Discuss the factors that affect the ability of courts to make laws. So, what affects the ability of the courts to make laws is our question today. So, straight into it, we're going to take the same process that we did with Parliament, and basically for each factor that they give us in the study design, like precedent, we are going to then look at what it is and then how it affects the ability of courts to make law. So precedent from 4.2.2 we should know is about how courts, the decision that courts hand down on cases is then used to inform future decisions. So particularly if a higher court hands down a decision, if there is a similar case in the future in a lower court, the lower court must or is bound to follow the decision that the higher court made previously. And then same or similar the other way, if a lower court hands down a decision, a higher court is persuaded to and kind of expected to make the same decision, although they do have the ability not to. So this is the idea of stare decisis. Sorry, bit of a yawn there. This is the idea of stare decisis, to stand by what has been decided. That's what the courts are going for. So how does it affect the ability of courts to make law? Well, in the first instance, it just is the ability of courts to make law. Like, this precedent is how courts make law. The decisions a higher court makes must be followed by the lower courts. That's law, it's binding, or at least influential. So precedent is how courts make law in the absolute first instance. However, there are obviously situations where precedent is going to be limiting. Courts are unable to make law if they're bound by a previous decision. So lower courts, for example, so precedent can impact or limit their ability to make law. Statute law, so law made by parliaments, also always overrules courts' decisions. So if there's a statute covering the fact situation, courts don't have the ability to create a precedent if that statute is clearly defined. However, judges might be able to distinguish their case from previous cases, so they don't have to follow precedents. But we're going to look at judicial conservatism. Judges might just be unwilling to make the law or change the law if there's a persuasive precedent in place. And we'll look at the idea of conservatism in a moment. So a few things either way here, and when we get to discussing at the end, I'm going to show you a table that has both how they make law, and again, precedent is their ability to make law, but how precedent might be limiting. Then you go to judicial conservatism, and judicial conservatism is really just a limiter, and the next 2 points, conservatism and activism, really work together. So this is the idea that a lot of judges are conservative in nature. They adhere strictly to stare decisis, so the thing to stand by what has been decided, so the previous decisions of courts. They absolutely view lawmaking as the responsibility of Parliament. They view the fact that courts have a secondary role as lawmaking as just that, secondary, and something that they avoid. So this limits the court's ability to make law quite heavily, because it means judges are unlikely to take opportunities to make law, and they may apply outdated precedents, even if it's morally right to change the law. A really clear example of this, and it's going to come up in the relationship slides at 4.2.5, is when the Australian High Court effectively, and this isn't 100% as detailed as it should be when I explain it, but effectively there was a court case where a farmer hadn't maintained their fences, sheep got in the road, caused a car crash. There was a British precedent from a very long time ago that said that farmers should not be responsible for their livestock, and the Australian High Court, with a bit of judicial conservatism at play, decided that they would apply that precedent. It wasn't their role to change that, and Parliament essentially came in afterwards and made a law that said you're responsible if your livestock go on the roads. So the opposite of judicial conservatism is judicial activism. And it's just effectively, I think you all know what an activist is and what the word activism means. And it's just the idea that some judges actually believe they have a social responsibility to develop the law. So you've got some judges who are like, Parliament's job, we're never going to do it. And you've literally got other judges who are like, society changes, it is our responsibility to try and update the law in line with society. So this means judicial activists are more likely to change the law. The Mabo case is, as it says there, a prime example of judicial activism. It overturned the precedent of terra nullius, that Australia was uninhabited at the time of British arrival, that had been precedent for well over 100 years. And there were definitely, that was a 4-3 decision of the High Court, if I remember correctly. So there were people that, or judges that didn't think they should change the law there. Then you have costs and time. Now we're strictly really getting into limiters here. How does this affect, or what is it? Well, this is the stuff we've been talking about since right back in criminal and civil law. Bringing a legal case is incredibly expensive. We know filing fees, court costs, legal representatives in particular, and the costs of a solicitor to look at documents and a barrister per hour or per day in court. And just it takes a long time. Like, cases might not be resolved for years. I'm sure many of you would have looked at the Mabo case at year 11, where Eddie Mabo actually, by the time the case was heard and then appealed and ended up in the High Court, Eddie Mabo actually died before the decision was handed down, because the process took about 8 years, I think it was. So the process takes a long time, and that helps to drive up the cost as well, which just essentially limits the opportunities that courts have to make law, because people aren't going to bring cases if they can't afford it, if they don't have the time, or particularly if they lose, they're going to have to wear the cost of the other party as well. And the requirement for standing. Now, this is again really focusing or focused as a limiter. We've talked about this briefly before through lots of other videos, this idea that you can only bring a court case if you have standing. It means you have to have a special interest in the matter, which usually means you have to be personally affected by it. So you have to be personally affected by the law that you are challenging. If it's a civil case, you can't bring a case on someone else's behalf effectively, unless there's special interest. Just answered my own question there. No, and the example I'll use, effectively you can't bring it on someone else's behalf unless you have that special interest. An answer there being the Victorian IVF case, McBain, the state of Victoria. So John McBain was an IVF doctor who brought it the case on behalf of his patient, because he had a special interest in figuring out whether the law in Victoria was discriminatory or not. And this is the whole idea that judges just can't go out and do their own thing. Someone has to bring a case first, so it does limit the ability of courts to actually act as lawmakers. So we are discussing the factors that affect the ability of courts to make law. So we looked at this same dot point for Parliament, and I've got actually a few questions that you might get to try and give you a bit more of a clear understanding of what we might be looking at. So this is a question from the 2012 exam. This is probably my favourite legal studies question ever, just because it includes like a little op-ed comment from Concerned Con from Kyabram. But the comment is, why are judges able to change laws? They should not be able to change laws. And then discuss the ability of courts to change the law, which is effectively this. Discuss the factors that affect the ability of courts to make law. So it's effectively slightly reworded, but the sort of this skill from the old study design. So what it does is it gives us this fantastic list of when courts can change the law and when courts can't. So I definitely recommend pausing this and reviewing these lists. It'll include things like courts can change the law through statutory interpretation, which we looked at in 4.2.3. They can establish precedent where there is no statute or common law, but they can't change the law when they're bound by precedent. They can't change the law until a case comes before them, so they're unable to change laws at their will, so standing. They can change the meaning of words in statutes, but they can't change the actual words. So there's lots of how they can change and how they can't change here, which is really, really good to look at and a little bit of the start of the sample answer. This question is... I should get rid of that there. Discuss how judicial conservatism and activism affects the ability of courts to make law. And this is the fact that there's an interplay between those 2 points, like I said. And this is where we bring this table in. So it'll have those 5 things, including 2 of them in here. So precedent, judicial conservatism, judicial activism, costs and time, and requirement for standing. And then just how they are limits, how they do limit the court's ability to make law, but how they don't limit, which is also really important, so we can discuss it. So again, just a couple of brief dot points. Requirement for standing doesn't limit the court's ability to make law. It just makes the situation less likely. But the courts can't make law by themselves, so they are limited by the requirement of standing. Precedent is their ability to make law. However, judges may be unwilling to overrule or reverse a precedent, which is in line with judicial activism. So on and so forth. Cost and time, again, doesn't actually limit their ability, just makes the situation less likely. So have a look at these, be prepared to be able to construct an answer that looks at both sides, and a question as simple as discuss the ability of courts to make law. And you could also get a question like this, and this is off the sample exam. Explain one reason why the court may not be able to change the law in this case, and it has that this is part of the case study section of the exam, and here you'd be looking at identifying a reason and then going into some depth and linking back to the case study about why the courts might not be able to change the law. In that example, I would highly recommend that you look at this question perhaps with your teacher and with your class about how you might go about constructing, because it is quite tricky. You only are allowed to bring in one reason because it says only one, but you've got to get 4 marks for it. And I'd say ideally you'll be looking at the concept of precedent and how the courts may be bound to hand down the same decision as previously. Interesting little link, Khan Academy. Don't do a lot of legal studies stuff that I can find, but they do have a video. It is American, hence why a lot of stuff's not relevant, but it's an American Khan Academy video on judicial activism versus judicial constraint, which is effectively judicial conservatism, and looks at the US Supreme Court. So it's kind of interesting. You might learn something new just by having a look at that. So we've rushed through this one pretty quick, but as I said, the key focus is on discussing and making sure we can know both the court's ability to change the law, but also what limits that, and particularly being able to respond to direct questions on, direct questions on precedent, direct questions on conservatism, activism, etc., because we might get those. So ultimately, can you answer what affects the ability of courts to make law? Hopefully you can. This has been another video for the Legal Studies guy. Get around us on Facebook and subscribe on YouTube. And hopefully we'll get you through to the exams in one piece.